Good morning, Doc Joey. Good morning, classmates. Today I will be reporting about the Daubert Standard, or otherwise called as the Daubert Principle. Now, what is the Daubert Standard? Okay. Now, the Daubert Standard is a rule of evidence relating to the admissibility of expert witness testimony during legal proceedings in U.S. federal courts. So, it determines the admissibility of expert testimony. Now, as established in Daubert versus Merrill Doe Pharmaceuticals Incorporated in 1993, the standard aims to ensure that expert testimony presented before the court is both relevant and reliable. It replaced the older Fry standard, which focused solely on the general acceptance of scientific evidence. And uh, the principle empowers judges as gatekeepers, ensuring res- the testimony is grounded in sound scientific methodology. Now, there are criterias of the Daubert standard to determine admissibility. Okay. Now, the judges will consider several key criterias. First is the testability, or can the expert's theory or technique be empirically tested? Second is peer review and publication. Has the methodology been subjected to peer review and been published in credible journals? And the third is error rate, or what is the known or potential rate of error associated with the technique. Next is the standards. Are there established standards governing the methodology? And lastly, the general acceptance. Is the methodology generally accepted within the relevant scientific community? Now, these criteria ensures that the expert testimony is scrutinized not only for its acceptance but also for its scientific rigor. Second. Now we will talk about the evolution and expansion of the Daubert standard. And initially, the standard was limited to scientific testimony only, but the Daubert standard expanded to include technical and other specialized knowledge in subsequent cases. So the cases are Kumho Tire Corporation versus Carmichael in 1999. This expanded the Daubert standard to apply to all forms of expert testimony, including technical expertise. I will talk about these cases later in the report. Okay. Second is the General Electric Corporation versus Joyner in 1997, which established the trial court's decision regarding expert testimony um, re- reviewed under the abuse of discretion standard on appeal. Now, the practical application. So, in practice, a Daubert hearing is typically held before a trial to assess the admissibility of expert testimony. For example, in medical malpractice cases, an expert's opinion on the cause of a condition would be evaluated based on the Daubert factors. Okay, now this process ensures that unreliable or speculative methods are excluded from jury consideration. Now, the Daubert standard has become the dominant standard in federal courts, although some state courts continue to apply the Fry standard. Key concepts. Okay. Now, in application, we must remember that these following key concepts to okay, okay, I'm sorry for that. Now, okay. The first is that the expert testimony must be relevant and a good fit for the case in order to be deemed helpful to the trier of fact. The trier of fact is the judge, the lawyers and the judge. Okay. Or the jury. Second is the witness must also be properly qualified as an expert through education, training, experience, or otherwise. Any opinion offered must fall within the witness area of expertise. So the expert must be knowledgeable in that field. Okay. Lastly, the expert testimony must satisfy the three-part reliability test found in Rule 702 to be admissible. Okay. So to be admissible, the testimony offered by an expert witness must be first relevant, second from a witness properly qualified as an expert, third reliable per the three-pronged test rule of 702 and Daubert, and D the testimony must not be excluded by another rule of evidence, such as Rule 403 or unfairly prejudicial. Oh, okay. Now, when we say relevant, the expert testimony must assist to the trier of fact to understand the evidence or to determine a fact in issue. And also, the expert testimony must also fit the facts of the case. Second, from a witness properly qualified as an expert. Now, the proposed expert witness must also be qualified as an expert by knowledge, skill, expertise, training, or education, as mentioned earlier. The common issue here is whether an expert is testifying outside his or her area of expertise. Third, reliable. Okay, the testimony must be reliable per the three-pronged test rule of 702 and Daubert. Now, under the Daubert standard, expert testimony in the form of an opinion may only be offered into evidence if, first, if the testimony is based upon sufficient facts or data. Second, that if the testimony is the product of reliable principles and methods. And third, if the witness has applied the principles and methods reliably to the facts of the case. Now, this revised standard applies to all cases commenced. Example, those cases that are charged or indicted after October 1, 2011. So after no, walang hindi pwedeng before. So it's not retroactive. The challenges here under Daubert standard is if the expert testimony involves new technologies, untested methods, or an unusual area of expertise, the opposing party may seek to challenge the admissibility of that testimony on Daubert 702 grounds. Now, how? Okay. So how? First is in motion in limine on voir dire hearing. Second is it may be brought prior to trial or motion during trial. Okay. Now a motion attacking. Okay, before I proceed, it's actually voir dire and in limine. So before I proceed, I will just explain um what they mean by in limine. So this motion in limine is a pre-trial motion asking that certain evidence be found inadmissible and that it not be referred to or offered at trial. Okay. Um, the voir dire, on the other hand, is a procedure during a trial that helps a judge decide on certain issues. It is a process by which an expert witness are questioned about their background, qualifications before being allowed to present their opinion or testimony in court. Okay. Now, a motion attacking expert testimony should be brought within a reasonable time after the close of discovery. No. you cannot just file a motion anytime, no. It must be brought within a reasonable time after the close of discovery, and that the hearing should be made well in advance of the first time a case appears on a trial calendar. Now, the Daubert trilogy. These are the famous cases under the trilogy that shaped this principle. Okay. The Daubert versus Merrill, General Electric Corporation versus Joyner, the Kumho versus Carmichael. I also placed that in the report about the case digests or brief case presentation of these cases. We will talk about the last key component, that a testimony must not be excluded by another rule of evidence, such as Rule 403, or unfairly prejudicial. Now, even if the expert testimony is otherwise admissible under 702, if the court may still exclude it under Rule 403 if it is unfairly prejudicial, misleading, or confusing. Similarly, supporting evidence for the opinion that would otherwise be admissible under Rule 703, or the basis of opinion testimony by experts, or Rule 705, disclosure facts or data underlying expert opinion, may be excluded if it is deemed inadmissible under Rule 403. Now, Rule 403, or this is excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. So, the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following. First, unfair prejudice. Second, confusing the issues. Third, if it is misleading the jury. Fourth, undue delay. Five, wasting time. And lastly, the needlessly presenting cumulative evidence. Now, what is meant by probative value is that in evidence law, it is tending to prove something. So the evidence must tend to prove something. Testimony which is not probative, does not prove anything, is immaterial and not admissible or inadmissible, or will be stricken from the record if objected to by opposing counsel. Now, when is the standard used in criminal cases? So, the Daubert standard came about because Federal Rule of Evidence 702 requires that expert testimony consists of scientific, technical, or other specialized knowledge that legitimately helps the finder or the jury or the judge understand the evidence or issues that have been raised in the case. Now, these are the things a judge should consider in deciding if the science and the expert in question should be permitted. Okay. Now, first is, what is the expert's theory and has it been tested? Second, are there standards controlling the theory's operation? Third, has the theory or technique been subjected to peer review and publication? Fourth, what is the known or potential error rate? Same ra ganina, no? And fifth, is there general acceptance of the theory by the scientific community? Sixth, has the expert adequately accounted for alternative explanations? And lastly, has the expert unjustifiably extrapolated from an accepted premise to an unfounded conclusion? So, now the conclusion is the Daubert standard has significantly impacted the way courts assess expert testimony by emphasizing scientific validity, testability, and reliability. The judges play a critical gatekeeping role, evaluating not just the experts' credentials but the methodology behind their opinions. This standard ensures that juries are presented with testimony that is both scientifically sound and relevant to the case, fostering a more rigorous judicial process in both civil and criminal litigation. So, we have mentioned earlier these cases that collectively shape the current framework for the admissibility of expert testimony. Uh, we'll talk about the first case. The Daubert versus Merrill Doe Pharmaceuticals Incorporated in 1993. These are the facts of the case. This case arose when the plaintiff's two minor children alleged that their birth defects were caused by their mother's use of a prescription drug called bendectin during pregnancy, which was manufactured by Merrill Doe Pharmaceuticals. The plaintiffs presented expert testimony suggesting a causal link between the drug and the defects. However, the scientific methodology supporting their experts' testimony was not generally accepted in the scientific community before. Okay. So the issue is whether the general acceptance test from Fry versus United States 1923 was the appropriate standard for determining the admissibility of scientific expert testimony under the rules of evidence. Okay. So the ruling is that the US Supreme Court ruled that the Fry standard was superseded by the more flexible Daubert standard under Rule 702 of the Federal Rules of Evidence. The court held that judges must assess whether the reasoning or methodology underlying the expert testimony is scientifically valid and can properly be applied to the facts at issue. Now, the decision set the following factors for determining admissibility. This has been mentioned earlier in the report. Whether the theory or technique can be tested, whether it has been peer reviewed, the known or potential error rate, the existence of standards controlling the technique's application, and whether the theory or method is generally accepted in the relevant scientific community. Okay. So, uh, the Dobbert standard superseded the Fry standard. And why is this significant? This is because the ruling transformed the role of trial judges into gatekeepers who are responsible for ensuring that any expert testimony presented to the jury is both relevant and reliable. The decision replaced the Fry standard and introduced a broader evaluation of scientific evidence in federal courts. Now, why is this important to forensic psychology? Okay. Now, the Daubert versus Merrill Doe Pharmaceuticals established a more rigorous standard for admissibility of expert testimony in court, requiring judges to critically evaluate the validity and reliability of scientific evidence. This has significant implications in forensic psychology as it now affects how psychological assessments, behavioral theories, and expert testimony are scrutinized in legal settings. Forensic psychologists now must ensure that their methods are scientifically sound and aligned with Doubert criteria. Okay. In Kumho Tire Corporation versus Carmichael, okay, the facts of the case is that in this case, the plaintiff Patrick Carmichael sued Kumho Tire Corporation after a tire failure led to the death of a passenger in his minivan. The plaintiff sought to introduce expert testimony from an engineer who would testify about the cause of the tire failure. The defendants challenged the testimony on the grounds that the methodology used by the experts was not scientifically reliable. So the issue at hand is whether the Daubert standard for the admissibility of scientific expert testimony also applies to technical or other specialized knowledge that is not strictly scientific. The U.S. Supreme Court held or decided that the Daubert standard applies not only to scientific testimony but also to all expert testimony, including technical and specialized knowledge such as engineering expertise. The court ruled that trial judges must ensure that expert testimony, whether scientific, technical, or otherwise, meets the same standard of reliability and relevance. This is significant to the court, as this decision extended the Daubert standard to all types of expert testimony, reinforcing the judge's role as a gatekeeper in assessing again the reliability and relevance of expert evidence in any specialized field. Okay. So, why is this important in forensic psychology? Now, Kumho Tire broadened the scope of the Daubert standard, reinforcing that forensic psychologists' testimony, whether scientific or clinical, must meet reliability and relevance standard. The court's decision emphasizes that even clinical judgments in forensic psychology must demonstrate reliability under Daubert criteria to be admitted in court. Hmm. We also have General Electric Corporation versus Joyner. So, this case, Robert Joyner filed a lawsuit against General Electric, claiming that his exposure to chemicals produced by GE caused his cancer. In support of his claim, lung cancer. In support of his claim, Joyner presented expert testimony linking his cancer to the chemical exposure. The district court excluded the testimony, deeming it speculative and lacking sufficient scientific support. Now, Joyner appealed, arguing that the trial court had wrongly excluded his expert testimony. So, what is the issue? The question is, what is the proper standard of review for an appellate court to apply when assessing a trial court's decision to admit or exclude expert testimony under Daubert? So the U.S. Supreme Court ruled that the proper standard of review is abuse of discretion. So they must look into the abuse of discretion. This means that an appellate court should give deference to the trial court's decision to admit or exclude expert testimony unless it was a clear abuse of discretion. In this case, the Supreme Court upheld the district court's decision to exclude the testimony. Okay. Now, why is the ruling important? So, this is significant because the ruling established that appellate courts should defer to trial courts when reviewing decisions regarding expert testimony, thereby granting trial judges substantial discretion in their role as gatekeepers under the Daubert standard. Its importance to forensic psychology. The Joyner decision reinforced the trial court's authority in determining the admissibility of expert testimony and established that courts have the discretion to exclude expert opinions that lack a reliable scientific foundation. Okay, so at- when the RTC, the first court is the RTC Magad. So when it is elevated to a high Sorry. So, when the court is elevated to a higher court or the appellate court, um, usually the appellate court respects or yeah, kanang respects the RTC's decision and decides or usually reinforces the trial court's authority in the determining whether an evidence must be accepted or not. Okay. Now, this affects forensic psychology by underscoring the importance of a strong empirical basis for any claims made in court and limits speculative or weakly supported psychological theories from being admitted. Okay, let us go to the last case, which is the Fry standard. Okay. In this case, huh, established in Fry versus the United States in 1923, this standard governed the admissibility of expert testimony in U.S. courts for decades. The case involved the use of a polygraph test, and the court ruled that scientific evidence could only be admitted if it was generally accepted by the relevant scientific community. So the issue is whether the expert testimony based on a scientific technique, like a polygraph test, could be admitted in court. So the court ruled that for scientific evidence to be admissible, the method must be sufficiently established and generally accepted by the relevant community. This standard applied a relatively high bar, often excluding newer or less widely accepted scientific methods from being introduced as evidence. Okay. So, the Fry standard's significance to courts was it was the dominant rule for admitting scientific evidence under the Supreme Court's decision in Daubert, which replaced Fry with a more flexible approach that considers the scientific validity of the evidence rather than its general acceptance. Okay. So, why is this important to forensic psychology? The Fry standard initially shaped the admissibility of psychological testimony in court, ensuring that only widely accepted theories and methods would be considered. Although the Daubert ruling eventually replaced Fry as the standard in federal courts, some states still apply Fry, making it relevant for forensic psychologists to understand general acceptance within their field and adapt depending on jurisdiction. Jurisdiction pa rin ano. So the summary of this impact. Okay, these landmark cases, the Dubho, Kumho, and Joyner, along with the earlier Fry standard that we have discussed, have collectively shaped the framework for the admissibility of expert testimony in U.S. courts. The Dobbert standard has superseded Fry in federal courts, introducing a rigorous method for evaluating the relevance and reliability of expert evidence and expanding the scope of judicial scrutiny to include all types of expert testimony. Saba kayo akong baby. So the rulings have reinforced the critical gatekeeping role of judges in determining the scientific and technical soundness of expert opinions presented in courtrooms. Okay. So here is an example of Fry versus Daubert. Okay. Now imagine a criminal trial where a forensic psychologist is testifying on the defendant's mental state during the crime using a new psychological assessment method for evaluating diminished capacity. So, if you use Fry standard, no, under Fry derived from Fry versus US, the expert testimony is admissible only if the scientific method or technique is generally accepted within the relevant scientific community. The application of this would be the forensic psychologist would need to demonstrate that the new assessment method is widely accepted among psychologists specializing in forensic assessments. So, what would be the outcome? If this method is relatively new and lacks consensus among forensic psychologists, the testimony would likely be excluded under Fry due to insufficient general acceptance. So, if we use Daubert standard, under Daubert standard, the judge acts as a gatekeeper to assess reliability and relevance of expert testimony based on several criteria, not just general acceptance. So, the applying this to the case, the forensic psychologist's method would be evaluated against Daubert factors: the testability, the peer review, the error rate, the standards and controls, the and the acceptance. Okay. So using these methods, what would be the outcome if the Dobbert standard would be used? If the assessment method meets several of these criteria, such as testability and peer review, the judge may admit the evidence, even if it is not yet widely accepted. Okay. Mhm. So, in summary, Fry focuses narrowly on general acceptance, potentially excluding newer but scientifically sound methods, while the Doubert provides a more flexible framework, allowing the court to consider various indicators of reliability and scientific validity. Okay. Scientific validity, making it more likely to admit innovative techniques if they meet the standards requirement. Okay, so that's it for my report. Thank you so much for listening. Bye.